Alright, this is the State of Wisconsin Court of Appeals, District 2. This is Stephen Avery's first appeal attempt of the State of Wisconsin versus Stephen Avery. Appeal from judgment of the order entered in the Circuit Court for Manitowoc County, the Honorable Fred H. Hazelwood, Circuit Court Judge presiding. Brief and appendix, the defendant appellant. Stephen Glenn's his attorney. Table of contents, table of authorities, issues presented for review, statement of oral argument, publication, statement of the case, statement of facts, argument. 1. Newly discovered evidence mandates a new trial. A. Avery was not negligent in seeking the DNA evidence, which was neither discovered nor discoverable until long after trial. The DNA test results are material to contested issue of identification. The DNA evidence is not cumulative. The newly discovered DNA evidence creates a reasonable probability of different results at retrial. And we'll move on. Newly discovered DNA evidence satisfies reasonable probability standard. The Circuit Court's decision was based on faulty assumptions. The PCR test results would have been admissible. And because Avery's supplemental motion alleged facts which would entitle him to a relief requested, the Circuit Court erred in denying the motion without a hearing. And the conclusion. These are all the cases they were citing during his appeal. Issues presented for review. Whether the results of DNA analysis of the fingernail scrapings from the victim revealing the presence of DNA which could not have come from either the victim or the defendant, and which was most likely came from the true perpetrator of the offense, constitute newly discovered evidence mandating a new trial. The Circuit Court held that the newly discovered evidence did not mandate a new trial, and Judge Hazelwood is the one that signed off on that. Whether Avery is entitled to remand an evidentiary hearing or due process claim for a new trial on the grounds that the Manitowoc County Sheriff's Department had identified an alternative suspect living in Sheboygan County who matched the description of the perpetrator but failed to provide the material exculpatory information either to Avery's trial counsel or to Avery's counsel in the initial appeal. The Circuit Court summarily denied Avery's supplemental motion, which raised the due process claim. Statement of the oral argument and publication. An oral argument is appropriate under Wisconsin statute. Appellant arguments clearly are substantial and do not fall within the class of frivolous or near frivolous arguments concerning which oral argument may be denied under Rule 80922. At such time as counsel for appellate has sufficient opportunity to review the brief for respondent and may be the oral argument when necessary, because the briefs may fully present and meet the issue on appeal. Until the brief and respondent has been reviewed, however, appellant wishes to preserve his right to request oral argument. Because Avery's entitlement to relief is clear, which decision requiring only appellant application of settled law to a slightly different factual situation that previously addressed, publication probably is not justified under Wisconsin statute. On the other hand, the Circuit Court's misinterpretation of the controlling standard for when the evidence creates a reasonable probability of a different result on retrial may evidence more widespread misunderstanding among the lower courts, so publication would avoid future such errors. State of Wisconsin versus Stephen Avery. Brief and dependent appellant statements of the case. On the afternoon of July 29, 1985, someone viciously attacked Penny Bernstein near Shota Beach in Manitowoc County, Wisconsin. Stephen Avery subsequently was charged and convicted following a jury trial in the Manitowoc County Circuit Court for first-degree sexual assault, attempted murder, and a false imprisonment regarding the incident. Footnote 1. As he did in the lower court, Mr. Avery uses only the victim's initials, PB, and identification in the brief. While he submits that the innocent and she is mistakenly identified as an attacker, there is no doubt that PB was subject to a savage attack by someone Mr. Avery does not seek embarrasses her in a way with the motion of his appeal. The court, Honorable Fred Hazelwood presiding, sentenced him to 32 years imprisonment on March 10, 1986, and entered judgment. Penny Bernstein was the sole eyewitness against Mr. Avery and the only one to identify him as the perpetrator. Approximately 16 other witnesses testified that Avery was elsewhere at the time of the attack. The jury nonetheless convicted this court affirmed on Avery's direct appeal, and the Supreme Court denied a petition review on October 13, 1987. On June 13, 1995, the new counsel filed a motion with the Circuit Court seeking release of certain trial exhibits, scientific testing, and anticipation of a post-conviction motion under Wisconsin Statute 9706. Specifically, the defendant sought to perform DNA analysis on the fingernail scrapings taken from the victim by the state agents while performing a sex crime kit soon after the assault. The fingernail scrapings were identified in the crime lab report as containing trace amounts of human blood, but at the time of trial. Another footnote. Throughout this brief, references to the record will be the following from R with R reference denoting the record document number and the following reference denoting the page number of the document, where the referenced material is contained in the appendix. It will be further identified by the appendix page number, blah, blah, blah. A state crime laboratory technician was unable to type the blood found there. A stipulation in the order dated November 29, 1995, the Circuit Court directed the release of fingernail scrapings from Penny Bernstein for DNA testing by Laboratory Corporation of America. Based upon the results of the analysis, Avery filed a motion pursuant to Wisconsin Statute 9706 on April 24, 1996, seeking a new trial on the grounds of newly discovered evidence. On July 30, 1996, Avery filed a supplemental motion post-conviction relief based upon the discovery that the Manitowoc County Sheriff's Department had identified an alternative suspect living in Sheboygan County who matched the description of the perpetrator but failed to provide the information either to Avery's trial counsel or Avery's counsel at the initial appeal. On July 30, 1996, the Circuit Court, Judge Hazelwood. Another footnote, the motion also sought release of pubic hair for testing. While the portion of the motion was granted, the hair had insufficient DNA for testing. Well, that's funny because that's exactly what freed Stephen Avery. The motion also contained a contingent claim of ineffective assistance of counsel in the event that the state claimed that the Avery's prior attorneys were negligent in failing to seek DNA testing of the fingernail scrapings, because both parties in the Circuit Court agreed the type of DNA testing the issue was available at the time of Avery's trial and direct appeal, and the prior counsel accordingly were not negligent in failing to seek such testing. Avery was not required to press the claim. Back to on July 30th, 1996, the Circuit Court Judge Hazelwood presided held an evidentiary hearing on Avery's newly discovered evidence claim. The parties stipulated the chain of custody and admissibly the DNA evidence. Anita Lynn Matthews, Assistant Director of the Forensic Identity Testing Section of the Laboratory Corporation of America, testified by telephone that the parties stipulated to her expertise that the state agreed that there was no quality control problems with her tests. Ms. Matthews explained that DNA stands for I'm not even going to try. DNA and chemical compound found in the nucleus of the cells throughout the body is present at the time of conception, with the other half coming from the mother in the egg and the other half coming from the father in the sperm. DNA is divided up into what are called chromosomes and chromosome. Some is basically just compartmentalized of DNA. Each individual has 46 chromosomes, or actually 23 pairs of chromosomes, which one member of the pair coming from mother, the other member of the pair coming from the father. DNA dictates that the chemicals and physical process that occur in the body, and because of everybody being human beings, we all have very similar, but all have a lot of similarities in our DNA, and that we all have hair and eyes and skin and gastric juices and stuff like that. There's a lot of similarities in DNA. There are also areas where a lot of variability have been noted in DNA, and this is the areas of variable with examined when doing DNA testing. Many cells from the body which contain a nucleus, such as skin or blood, could leave DNA present. Ms. Matthews also explained that DNA testing is done in a criminal case. DNA testing is used in a criminal case by comparing what we refer to as questionable sample and DNA is isolated. A questioned sample or an evidentiary sample to DNA that has been isolated. Known samples are collected for an individual compared to DNA profile between the two samples and the DNA. Profiles are consistent of each other. Then there are said though too they could have originated from the same source. If DNA profiles are different from each other, then they could not have originated from the same source. The DNA testing in forensic case is simply a comparison of DNA patterns between the questioned sample and the known sample. The DNA testing Ms. Matthews performed in the case involved first purifying the DNA in one half of the evidentiary sample to remove cellular debris, resulting in clean DNA in solution. Then she used the polymerase chain reaction technique, PCR, to amplify the DNA to specific regions or loci where variability generally is noted. The PCR essentially copies the DNA until there is enough to analyze. The detection method then is applied to visualize the different alleles from forms of DNA which are presented in each locus, presenting the comparison of the DNA in the evidentiary sample with the known samples. Following this procedure, Ms. Matthews isolated DNA from two separate preparations of the scrapings identified as coming from Penny Bernstein's right hand and was able to characterize in three specific genetic systems of loci, T-epoxy, THO1, and CSF. The results were consistent and known from Penny Bernstein. The results of the sample also indicated a mixture of DNA from at least two individuals. Ms. Matthews explained, normally an individual would have no more than two alleles present at least the locus and the fingernail preparation number to the T-pox locus, whatever the fuck that means. There were three alleles detected with the indication that there is more than one person present. Additionally, at the time, the THO1 locus with the alleles present that there were some additional activity, which indicates the more traditional and more discriminating form of DNA analysis, which was performed in the case, the RFLP, also known as more discriminating, requires a lot more DNA because it's not amplified. Starting from material, you have to have a lot more initial DNA to begin with, then required the PCR was not enough DNA present in the sample to perform the RFLP analysis. DNA from at least one other person. So was our opinion that the DNA profile from the prep was consistent with the mixture of the DNA from Penny Bernstein and at least one other individual. The results show that alleles 8, 9, 11 of the T-pox locus, Penny Bernstein, Avery both have alleles 9, 11 at the locus, as thus could not have contributed to the elite 8 allele. It had to have come from some person other than Stephen Avery or Penny Bernstein. From the results, Ms. Matthews could not tell how many individuals contributed to DNA in the sample, except that it had to be more than one. Based solely on the test results, Avery could not exclude as a possible contributor, along with Penny Bernstein, to the 9 and 11 alleles found in the fingernail scrapings. Given the 8 allele, however, findings based on other evidence, only 2 individuals contributed to the sample, and that one of them, Penny Bernstein, would obviously exclude Avery as a possible contributor. If there's DNA present in that, the preparation number 2 from only 2 individuals, one of those individuals, Penny Bernstein, the other individual could not have been Stephen Avery. Ms. Matthews also testified that the DNA has a long shelf life, as long as nothing happens that would remove the DNA or cause the DNA to become degraded. She also noted, however, that the normal day-to-day activity could remove DNA, such as by washing your hands, splashing, or swimming in the water, or lots of physical activity. For the court convenience, a copy of Ms. Matthews' certificate analysis including the appendix. On September 23, 1996, the Circuit Court heard oral argument on the motion and summarily denied the supplemental motion without a hearing regarding the newly discovered evidence motion. The court held the evidence was truly new discovered evidence in the sense that it didn't exist in the practical sense, wasn't available to counsel or the fact finder at the time of trial. The court nonetheless held the new evidence did not create a reasonable probability of a different result on retrial. On October 3, 1996, Circuit Court entered a written order reflecting denial of Avery's motion. Avery timely filed his notice of appeal on October 18, 1996, and this appeal follows. Statement of facts. About 3:50 p.m. on July 29, 1985, a man grabbed Penny Bernstein as she was jogging along the lakefront north of Neshota Beach. He pushed her to the wooded area behind the sand dunes, and then when she rejected his sexual overtures, viciously attacked her, beating her in the face and choking her, as well as forcing her to stroke his penis with her right hand. Penny Bernstein broke her fingernails when she clawed at her assailant. After the man left her, Penny Bernstein was able to crawl back to the beach where she received help. She eventually was taken to a hospital where a sex crime kit was completed, including the taking the fingernail scrapings, and her injuries were treated. In the meantime, Don Siegler, ready-mix driver, arrived at Alan Avery's home at 1 p.m. on July 29, 1985. Alan Avery had also had his son, Stephen Avery, to come over and help pour cement that day. Stephen helped hold the chute during the pouring of the slabs for the sheep barn, and then they helped Lloyd shear edge the cement. Chuck Steffen and Chuck Avery were also helping. Siegler, the cement truck driver, said he thought he left around 2:30 p.m. While the men were pouring cement, Stephen's wife Lori, his mom Dolores, his sister Barb, Rosie Scher, Jody Blankill were in the house. They watched divorce court on television from 3 to 3:30. When the show was over, Stephen asked Lori to get his kids dressed and ready to leave while he took Barb in his 1976 Blazer to the gravel pit. After returning from the gravel pit, Stephen took his wife and children to Green Bay, where they washed the Blazer, got something to eat, and bought some paint at the Shopko store before returning to his father's place. Stephen and Lori briefly left to look at the accident down the road, and then waited for his brother Earl so they could do something plastering at Stephen's place. Stephen and Lori arrived home at 9 p.m. After Stephen and Earl plastered, they went to bed at around 11:30. About a quarter to midnight, the dogs barked and Lori saw someone enter the garage. Stephen pulled on his pants. His uncle, police officer Arlen Avery, called up and asked Stephen to come downstairs. Officer Froelich, very, very good name. Officer Froelich was in the living room, and another officer was standing by the door. They told Stephen he was under arrest for reading this right. Stephen told he was under arrest for attempted degree murder or something. Lori asked what was going on, and Stephen responded that I murdered somebody or something. Officer Kenneth Peterson testified. Stephen said, they say I murdered a woman. Officer Froelich gave similar testimony. Peterson also said that on the way to the sheriff's department, Stephen asked where the lady lived. Marvin Mott is a very good name too, because it comes back up in 2006. It's funny how some of these names seem to be resurfacing. Stephen's sister Barb had been here, her dad's, from 11:30 a.m. to 5:30 p.m. on that date. She said that after divorce court, she and Stephen went for a ride in the gravel pit. After they returned, Stephen left. Lloyd Blank worked from 6 a.m. to 2 p.m. He got home around 2:30 p.m. and went to Avery's with some aluminum cans around 3 o'clock. He saw Stephen there and his dad at the time. Lloyd Blank left around 4 p.m. Stephen left right in front of him. Judith Blank was also there with her husband. She walked outside after divorce court, and the cement truck was not there. She and her husband talked for a few minutes. Then Lloyd talked to Stephen. Stephen left before they did. Lloyd sure remembered the cement truck coming shortly after 1 p.m. He worked with Stephen that day. He saw Stephen leave within 10 minutes of 4 p.m. Chuck Avery had seen Stephen take his sister Barb to the gravel pit around 3 p.m., 3:30 or so. Rose Sher watched Divorce Court from 3 to 3:30 p.m. After the show, she saw Stephen, who was outside and still helping her husband Lloyd. Chuck Steffen was working in the concrete project that day, and he had seen Stephen go to the gravel pit. Earl Avery was working in the red garage at his father's place. He saw Stephen working on the cement project, and Stephen later asked him to go to Green Bay with him. Stephen came back later, maybe after supper, and asked Earl to help him plaster. Pete Dassey had seen Stephen pouring cement. He estimated the cement truck left around 3 p.m. Eric Moan also was working on Alan Avery's place on July 29, 1985. He thought he saw Stephen go to the gravel pit with Barb Avery, but he did not see Stephen leave later for Green Bay. Dolores Avery, Stephen's mother, saw Stephen come in the house around 3:30 p.m. She thought he left around 4. Alan Avery testified that he thought the cement truck left between 3 and 3:30. He saw Stephen and Barb go toward the gravel pit with Stephen's four-wheeler. Alan testified that it was close to 4 p.m. when Stephen loaded up his family in the Blazer and left. Patricia Lax, Shopco employee, remembered seeing Stephen and his family in the Green Bay store on July 29, 1985, and identified a cash receipt tape marked 5:13 p.m. showing their purchase on that date. Investigator Pat Schiff testified that the travel time between Alan Avery's home and Green Bay car wash was 35 minutes. From the car wash to Burger King was 2 minutes, and from the Shopco, 3 minutes. Richard Missler of station WAV in Green Bay confirmed the divorce court was aired between 3 and 3 p.m. on July 29th. Before the during the trial, Penny Bernstein claimed that Stephen Avery was her assailant. She admitted, however, that she had initially described her assailant as having brown eyes, while Stephen Avery has blue. Argument 1. The newly discovered DNA evidence mandates a new trial. Contrary to the circuit court's holding below, the DNA test results consist newly discovered evidence mandating a new trial as a matter of due process. Due process requires a new trial if the defendant satisfies the following criteria. The evidence was discovered after trial. The defendant was not negligent in seeking an evidence. The evidence is material to an issue. The evidence is not merely cumulative to the evidence presented at trial. And 5, a reasonable probability exists that it never resulted in a new trial. Newly discovered DNA evidence fully satisfies each of these criteria. Indeed, the first 4 of these criteria were essentially undisputed in the court below. Avery was not negligent in seeking DNA evidence, which was neither discovered nor discoverable until long after trial. As the circuit court held, there can be no doubt that the DNA results constitute new evidence which was not discovered until after trial. Nor can I reasonably suggest that Avery was negligent in not seeking the evidence at the time of trial. Indeed, polymerase chain reaction type analysis required for the minute quantities of DNA available for testing in this case was only first devised in 1983. Will it soon achieve widespread acceptance in the fields of medical and biological research? Only one laboratory is performing the PCR test for forensic use, even as late as October 1990. The FBI did not even start doing PCR in the case until 1992 or early 1993. The DNA test results are material to the constituted issue of identifications. There likewise can be no doubt but the DNA test results are material to an issue, indeed the issue. In the case, by making it more probable that someone other than Avery committed the offense. Evidence as evidence having a tendency to make existence of any fact is of the consequence of the determination of the action more probable or less probable than would be without the evidence. Those DNA test results reflect that Penny Bernstein had close physical contact with someone, not Avery. sufficient to embedded testable quantities of the person's DNA under her fingernails, and that she did so soon enough prior to completion of the sex crime kit that she had person's DNA was not washed away in the course of basic good hygiene, jogging, or swimming that day. Note the ready distributed evidence under one's fingernails and the highly evident nature of such evidence. Only evidence of such actions in record concerns Penny Bernstein's clawings of the man who attacked her. The record indicates that soon before the attack, Penny Bernstein had splashed around in the water to cool off. Ms. Matthews testified that such activities likely will wash away any DNA under her fingernails at the point. Vigorously activity and sweating, as one would expect during a long run, likewise could wash away any previously deposited DNA. And her being forced to stroke the man's penis while he grabbed her right hand in his own, the most reasonable inference and only reasonable inference which a jury could draw from the evidence thus that the DNA came from assailant, that Mr. Avery simply is not the person who attacked Penny Bernstein. The DNA evidence is not cumulative. The DNA results are not merely cumulative in the evidence presented at trial, while the trial evidence impeached Penny Bernstein's identification testimony and established that it believed that Avery was somewhere else at the time of the attack. No hard scientific evidence presented at the first trial either helped to exclude Avery as the perpetrator or establish affirmatively the alternative likely perpetrator. In other words, the trial was credibly based wherein constant, while their newly discovered DNA test results actual physical evidence of Avery's innocence. The newly discovered DNA evidence creates a reasonable probability of a different result at retrial. The only real controversy below was neither whether the new DNA evidence meets the final Coogan criteria, raising a reasonable probability of a different result at trial. The circuit court held that it did not. The circuit court was wrong. This is an issue of law received. Ms. Matthews testified that the test results showed a mixture of DNA from at least two individuals. Given the extent of her injuries and the blood on her hands, one source of the DNA certainly was Penny Bernstein herself. Likewise, given Penny Bernstein's clawing at her assailant and her forcing her to stroke his penis with her right hand while grabbing the hand with his own, another source almost certainly assailant. Moreover, while the DNA results themselves could not show whether they were only two sources or more than two, most likely conclusion, the facts that record that there are only two, Penny Bernstein and her assailant. Unlike those two other sources, the other potential source wholly speculative on this record. The new evidence thus raises a reasonable probability of a different result on retrial on at least two grounds. First, Ms. Matthews explained that if, as most likely here, there were only two sources of DNA, and one of them Penny Bernstein's, the second could not be Avery. Given the only likely source of this record, Penny Bernstein or assailant, therefore, a jury easily could conclude that the test results absolutely exclude Avery as an assailant. Second, given that the only non-speculative sources of the DNA are Penny Bernstein and her assailant, and neither Penny Bernstein nor Avery could have contributed to the 8 allele, reasonable jury could conclude that the 8 allele must likely be the true perpetrator. Applicable legal standard. Supreme Court has held in an analogous context of the due process violation withholding exculpatory evidence that a reasonable probability and a probability sufficient to undermine confidence in the outcome. The DNA results showing Penny Bernstein clawed someone else, not Avery, more than established such a probability. The United States Supreme Court recently reaffirmed that to clarify the standard of maturity, the court held the Bogley standard does not require demonstration by preponderance of the disclosure of the suppressed evidence would result ultimately into a defendant's acquittal on the basis of presence of reasonable doubt or acceptance of the explanation for the crime that does not inculpate the defendant. Bogley's touchstone materials, reasonable probability of different results, and the objective to the important question is not whether the defendant would be more likely to have received a different verdict with the evidence, but whether his absence he received fair trial, understood a trial resulting in a verdict worthy of confidence, a reasonable probability, and different results, and accordingly shown when the government's eventual suppression undermines confidence in the outcome of the trial. The circuit court in Kyles also clarified related point that the reasonable probability standard under Bogley is not a sufficient of evidence test. The question is not whether, without the constitutional error, there remained enough evidence to convict. The possibility of acquittal on a criminal charge does not imply insufficient evidentiary basis to convict. One does not show a Brady violation by demonstrating that some of the inculpatory evidence should have been excluded, but by showing that the favorable evidence could have reasonably been taken to put a whole case in such a different light as to undermine the confidence of the verdict. While the case plainly does not involve the unlawfully holding exculpatory evidence, the same due process standard applies in case the first jury was denied relevant exculpatory evidence. The only difference is that the Bogley situation, it was denied that evidence by the state, while in the case the evidence did not exist. The newly discovered DNA evidence satisfies the reasonable probability standard. The DNA test results plainly meet the standard by creating a reasonable probability of a different result on retrial. Those results demonstrate Penny Bernstein clawed someone who was not Avery, and that evidence presented at trial identifies a perpetrator of this offense as most likely recipient of such attack by her. It was on the perpetrator from whom Penny Bernstein clawed and was such force as to break her own fingernails, and it was perpetrator who forced her to stroke his penis with her right hand, which he grabbed with his own. The presence of someone else's DNA under Penny Bernstein's fingernails, other than Penny Bernstein and the perpetrator, who wholly speculative on this record. The record demonstrates that prior to the attack, Penny Bernstein was jogging and splashing around the lake to cool off, activities which Ms. Matthew explained likely would remove any pre-existing DNA containing cells under her fingernails at the time. The situation is the same during the brief period between the attack and the completion of the sex crime kit. There is no evidence whatsoever that Penny Bernstein scratched anyone during that time. The best the state could manage below to argue that Nancy Peterson, a nurse who collected the fingernail scrapings, was not wearing gloves at the time. Patterson's trial testimony, however, is not so clear, with the reference to not wearing gloves applying in context, only placing a certain number of hair samples in evidence envelope. The head hair you put in an envelope that went into the kit that went to Officer Judy Dvorak. Are you positive that the hair that you put in the envelope was the hair you had obtained from the victim? Yes, they were. What were you wearing at the time when you did that? My nurse uniform, which consists of what? White paint suit, and you were wearing any gloves when you did that? No. A jury reasonably would construe that the testimony concerning gloves or applying only to the point in time when she did that. When she placed the hairs in the envelope, the state failed to present any evidence that the nurse in fact was not wearing gloves at the time she collected the fingernail scrapings, or that she took any actions which could have contaminated the evidence while completing the sex crimes kit. Despite having every opportunity to do so, the states likewise failed to have Nurse Patterson's DNA tested to determine whether she in fact is the 8 allele of the Tupac locus. Instead, the state chose to rely solely upon speculation that she might possibly have been the source. Whether or not the jury would buy the state's argument, that is to the jury which must make determination. A jury easily could reject the state's speculation. Once again, the most reasonable inference is not only the reasonable inference which the jury could draw the evidence that the 8 allele came from the true perpetrator, and that Avery thus is not the person who attacked Penny Bernstein. The true perpetrator only non-speculative source of the extra DNA under Penny Bernstein's fingernails, even if the evidence did not possibly exclude Avery. That the perpetrator, however, would still create reasonable probability of a different result on retrial, establishing the existence of a real alternative suspect, thereby strengthening the alibi of the defense. Discussing admissibility alternative suspect evidence, a reasonable jury rationally could conclude that on the facts here, the likelihood that the allele came from the true perpetrator rather than from the speculative casual contact at the small window of opportunity between the assault and completion of the sex crimes kit is just too high to ignore. The court also cannot ignore the fact that it was an extremely close case at the first trial without the DNA evidence. As the circuit court recognized, there was a lot of evidence and a strong case on Mr. Avery's side, whereas here, the verdict is already questionable validity. Additional evidence of relatively minor importance can be sufficient to create reasonable doubt. Penny Bernstein was the only witness to identify the defendant as the perpetrator, while approximately 16 other witnesses testified that he was elsewhere at the time and could not have committed the crime. Penny Bernstein's description of the perpetrator also did not match Avery, although she claimed to have a very good close-up look at his face and to absolutely certain about her identification of Avery. Penny Bernstein stated soon after assault that her attacker had brown eyes. Avery, however, has blue eyes. Penny Bernstein's attacker wore a white jockey-type underwear. Avery neither wore underwear nor he owned any. Attacker attempted to strangle Penny Bernstein, beat her in the face, and broke her nose, causing severe bleeding. The type of conduct which would expect to result in evidence on the perpetrator's fingernails. Evidence of strangulation is often found under an assailant's fingernails. Yet, while there was dirt in Avery's fingernail scrapings, indicating that he did not do a good job of washing them, state crime laboratory technicians found no blood. The circuit court decision was based on faulty assumptions. The circuit court's error in denying Avery's motion appears to have arisen from two core misconceptions, one of the law and one of the fact. The legal misconception was that Avery must bear the burden of proving the likelihood of a different result by clear and convincing evidence. Plainly is not the case, as the Supreme Court explained. Rather, whether evidence creates a reasonable probability of a different result is a purely legal question. This is the same standard applied to prejudice prong, the ineffective assistance of counsel test, under which he questioned and reviewed whether there's a reasonable probability that a jury viewing the evidence attained by counsel's errors would have reasonable doubt respecting guilt. The Wisconsin Supreme Court had held this legal question reviewed and underlying legal standard of prejudice and ineffective claims. Moreover, it's the same as the harmlessness of the constitutional violations. Discussion of the burdens of proof regarding such questions law is meaningless. The purpose of standard of proof is instructed to the fact finder concerning that the degree of the confidence of our society thinks he should have correctness of the factual conclusions for a particular type of adjudication. The burden of proof relates on the proof of facts and not application in cases involving undisputed facts. The circuit court's decision also appears to have been based upon a mistake of fact in discussing the relevant likelihood that the allele having come from a true perpetrator opposed to some speculative casual contact. Someone else, the court downplays probabilities of the former scenario. The court cites Penny Burns' apparent claim that, although she went after her assailant trying to scratch him, she did not believe she had succeeded, while conceding that it's not unreasonable to conclude that Penny Bernstein's statement that the DNA likely came from the DNA likely came from the assailant, and the court nonetheless found that it would be speculative in light of her contrary belief. Therefore, no more likely than the state's speculation that she possibly might have gotten the DNA from some other unidentified source. Wholly overlooked the circuit court, however, was the fact that the record demonstrates complete skin-to-skin contact between Penny Bernstein's right hand and her attacker, even separate from the clawing at him. Specifically, the record shows that Penny Bernstein was forced to stroke her assailant's penis right hand, and her assailant took his own hand and grabbed her while she did it. This uncontroverted evidence, direct physical contact between the victim's right hand and her assailant's skin, is far different, quintessentially the type of specific possibilities of casual contact relied upon the state here as a potential source of A allele. Although overlooked by the circuit court, a reasonable jury easily could find far superior quality of this evidence as deceived resolving whether A allele most likely came from a true perpetrator. Finally, the circuit court's decision also seems to have been based, at least somewhat, upon misguided deference of the jury's verdict. Now look at from the standpoint of the defense. This has been described as a closed case. I'm sure looked at from the standpoint of the prosecution, perhaps, they might say it is a closed case. But the call has been made by a jury that place a great deal of faith in those calls. They are not easily upset. What the position overlooks, however, is the jury's determination that the made of the particular vacuum with the newly discovered DNA evidence under such circumstances, deference is not justified. While I surely was providence to the jury to weigh the credibility of the bro's alibi, the jury was never given the chance to learn about Lee Crow, a second suspect. We believe that he had opportunity been given, but Owen's alibi would have been viewed in a different light. When viewed in light of the record as a whole, the circuit court here was wrong. The new DNA evidence created a reasonable probability of different result of the retrial, either because it excluded Avery as a perpetrator under the reasonable view of the evidence, or because the jury reasonably could view results as evidence of a different perpetrator, thus raising reasonable doubt even if it did not absolutely exclude Avery. Avery also notes that addressing whether evidence creates a reasonable probability of different result, the cumulative effect of such evidence be considered together. Accordingly, the court also must include the analysis of the effect of Manitowoc County Sheriff's Department concealment of the fact that they knew the alternative suspect was in the case. While the DNA evidence also meets this reasonable probability standard, combined effect of evidence concealed in the state even stronger, the PCR test results would have been admissible. On occasion, the court affirmed that denial of newly discovered evidence motion with the new evidence would not have been admissible in a new trial. Results not admissible, thus not newly discovered evidence, that the state conceded below, there can be no responsible doubt concerning the admissibility of the DNA test result in new trial. Still, Avery will discuss the point briefly to resolve any possible remaining doubts. DNA evidence inadmissible in Wisconsin. Specific type of DNA analysis involved here also has been found to be reliable and admissible under legal standards for more respective than applied in Wisconsin. At least all the states. Wisconsin, of course, applies the non-fray general acceptance test by the relevance test. The Wisconsin Supreme Court having rejected the Fry test to respective. Thus, the rule remains in Wisconsin that the admissibility of the scientific evidence is not conditioned upon reliability. Rather, scientific evidence is admissible if it is relevant. The witness is qualified and expert. 90702, stats, and 3. The evidence will assist determining issue of the fact. If the requirements are satisfied, evidence will be admitted. Once relevance of the evidence established and the witness qualified and expert, reliability of evidence, weight, credibility issues of the fact finder, and the reliability challenges made through cross-examination and the means of impeachment. As already demonstrated, the DNA evidence is relevant and would be helpful to a jury in determining a central issue, identifying the perpetrator. There also should be no dispute concerning the expert qualifications of the individuals who conducted those tests, and that the state itself stipulated that the testing done by Laboratory Corporation of America and Ms. Matthews' expert credentials. Accordingly, newly discovered DNA test results in the case would have fully admissible in the case. Because Avery's supplemental motion alleged facts which would entitle him to relief requested, The circuit court erred in denying the motion without a hearing. After filing Avery's 9706 motion, his present counsel learned that the Manitowoc County Sheriff's Department had identified an alternative suspect living in Sheboygan County who matched the description of the perpetrator, but failed to provide the information to either Avery's trial counsel or Avery's counsel on initial appeal. Avery's trial counsel specifically requested disclosure of such information prior to trial. Upon learning the information, Avery's present counsel filed a supplemental motion pursuant to Wisconsin Statute 9706, seeking a new trial on the grounds that the state's concealment of the information denied Avery due process. Avery's supplemental motion alleged that his present counsel spoke with Leo Jakowski concerning the case, that, based upon conversations, he believed that Mr. Jakowski would testify as follows at a given opportunity. Here we go. At the time of the case investigated and tried in 1985, Mr. Jakowski was a deputy in the Manitowoc County Sheriff's Department. Although Mr. Jakowski was not directly involved in an investigation of the case, he spoke about the matter with Lieutenant James Gospoderic of the Manitowoc County Sheriff's Department, who was so involved. Lieutenant G stated that Mr. Jakowski that he was aware of the man in Sheboygan County who matched the description of the perpetrator provided in this matter. Mr. Jakowski does not remember the name of the person Lieutenant G referred to. Based upon Lieutenant G's statements, Mr. Jakowski was under the impression that the man from Sheboygan County was under investigation with regard to this case. From his years of experience in law enforcement, Mr. Jakowski states that an officer normally should and will conduct an investigation when he sees he or she possesses such information, especially when the officer considers it significant enough to mention to a fellow officer. Mr. Jakowski further notes, based on his years of experience, that an officer who conducts such an investigation would and should file a written report of it, and at the very least, the officer would memorialize the investigation in his or her field notes. I guess they stopped teaching that class at Manitowoc. Lieutenant G passed away before Avery's counsel learned this information. The circuit court's summary denial of the motion without a hearing was error. The circuit court must grant a prompt hearing unless the motion and the files records of the action conclusively show that the person is entitled to no relief. The defendant is entitled to an evidentiary hearing if the motion alleges facts which is true would entitle the defendant to relief. Whether a motion raises sufficient questions of the fact to require an evidentiary hearing is reviewed. Whereas here the motion alleged sufficient facts to support claimed entitlement for relief from the court must remand the evidentiary hearing on this issue. Versing and remanding the evidentiary hearing, Washington to have alleged sufficient facts to support his claim that it denied effective assistance of counsel would have remanded the evidentiary hearing on the issue. Evidence of the Sheriff's Department had identified an alternative suspect in the next county which matched the description of the perpetrator and material exploratory under the standards. This was an extremely close case, as already demonstrated in Section 1, and the withheld information goes directly to the sole constant issue at trial, that of identification. The failure to disclose that the police were investigating an alternative suspect entitled the defendant to habeas relief. Failure to disclose information concerning an alternative suspect violated due process. In Bowen v. Maynard, the cert denied. The Court of Appeals affirmed the grant of habeas relief in the case very similar to that here. The defendant was convicted of triple homicide after being identified as the killer in a photo array. The lineup in the trial by 2 eyewitnesses, and despite his own testimony and 12 other witnesses that he was in a motor rodeo 300 miles away at the time. After trial, the defense learned that the police had considered a separate suspect who matched the description of the killer and who had both opportunity and motive and committed the crime. The Court of Appeals held that withheld evidence on another suspect violated due process and mandated a new trial. In language equally applicable in this case, the court held that where here, identifying this issue, a credibility alibi defense is presented and no physical evidence ties the defendant to the crime, material showing that someone resembling the defendant had motive, opportunity, ability to commit the crime is sufficient to undermine confidence in the outcome of the trial and meets the Bagley requirement to reasonably probability that the evidence had been disclosed to the defense resulting in a proceeding be different. Here is the bonus. Certain central trial issue with identification was a strong case on Mr. Avery's side in terms of the alibi. No physical evidence tied Avery to the crime. Under these circumstances, evidence that someone else from a nearby county resembled the assailant and would have the same motive and defendant would have been suspected by the police creates a reasonable probability of a different result at retrial. Even if the evidence actually developed regarding the alternative suspect from Sheboygan County did not itself raise a reasonable probability of the different result on retrial, the very fact that the Sheriff's Department sought to conceal this evidence does raise such probability. The Supreme Court has recognized that the sloppiness of the police investigation, such as the failure to investigate a possible suspect, can undermine the probative force of the states. While the knowledge of the police were investigating Mr. Newell would arguably carry sufficient weight with the jury in the trial itself, the fact would also have been useful in discrediting the caliber of the investigation and the decision charged the defendant. Citation omitted. A common trial tactic of defense lawyers is to discredit the caliber of the investigation or the decision to charge the defendant. We may just consider use in assessing this possibility of Brady violation. Avoiding a new trial. Prisoner convicted in Louisiana State Court because withheld Brady evidence carried within the potential for the discrediting of the police methods employed in assembling the case. Avery's supplemental motion demonstrates that at least one officer involved in the investigation of the case believed that further investigation of alternative suspect was necessary. Despite the fact that Penny Bernstein had already positively identified Stephen Avery as her assailant the same day she was assaulted, as the Supreme Court noted, if a police officer thought so, a jury would have too. Because his motion thus alleges facts which, if true, would entitle the defendant to relief, Avery was entitled to an evidentiary hearing on this claim, and the court does not grant a new trial in the light of DNA evidence. Therefore, it should remand for a hearing and supplemental motion. Conclusion. Because a reasonable jury could conclude that the DNA test results raise a reasonable doubt concerning whether Avery was the assailant and the victim alleged, or whether he was elsewhere at the time, and as 16 other witnesses testified, admission of the evidence would have created at least a reasonable probability of a different result. Avery therefore asked the Circuit Court reverse the court's order denying relief and remand this case for a new trial. If the court does not grant such relief, Avery asked that it remand for a hearing and supplemental motion dated in Milwaukee, December 20th, 1996. So yeah, this is Stephen's first attempt at getting test at new evidence, and it did him nothing. I will be going over the next appeal next, so those of you who are still watching, thanks for staying in there, and I'll see you on the next one.